Hello and good evening. Welcome to Defense Diaries. I am your host, Bob Mata, and this is our continuing coverage of all kinds of cases. It is our midweek roundup. Mandy came up with that name. It's pretty good. There was so much going on today. I thought that it was probably the best idea instead of trying to pick one particular case. We just kind of buzzed through all of them, give you the highlights. Now, there were a ton of things filed in Karen Reed today, and there is not a chance in hell that I'm reading all the documents. What we'll do, we're going to have a full live for it. Some of them are 14, 15, 17 pages long. A lot of stuff. I'll throw them up. We'll talk about them a little bit, but I'm not going to read through them. We'll save that probably for early next week. I had a death in the family. I'm flying back out to Florida tomorrow morning. Allie tomorrow announcement is going to be covering the closing arguments for APRocky. An interesting case that I kind of really wish that I would have covered because it's right up my alley. And my daughter, Cameron, my 18-year-old, loves him and loves his music. And she did that awesome little 2 minute and 12 seconds or 2:25 or something like that. Little stickman kind of short video that kind of highlights the case and gives you a real brief overview of what it's about. It's pretty good. I didn't know much about the case. I knew that it was heated. I knew that there was some real fireworks going on in that case because our friends over at with Linda and Michael, I think their channel's Justice Served, I think, we have been covering that case pretty heavily. So it's a case that I think that it's important that we have Allie sit with you tomorrow. She's already in Florida. She left tonight, so she's not going to be joining me this evening unless she surprises me. But I didn't even let her know I was going live, so that's doubtful. But all right, so let's start with, I've got a bunch of them pulled up, and the way I'm going to do this is I'm going to go through the different cases kind of one by one in terms of, let me see which one I want to go up through first. Okay, all right. So we got this one. All right, so I'm going to start with Cameron's thing with APRocky because that's a quick one. I think it's kind of a neat way to kind of go through a case. These are all her little hand-drawn stickman drawings, and she put this together last night. I'm always a proud papa with her, so I think she's brilliant and a total badass, just like her mommy. So we'll start with APRocky. I think this will give you a pretty good overview of that case if you don't really have any idea of what it's about. So let's check it out. 2 minutes and 24 seconds of glory. And wait till you hear her podcast voice. Pretty good.
You've probably heard the name APRocky in the past couple weeks, and here's why. APRocky is in a relationship with Rihanna that has resulted in 2 children. He also has his own successful music career. Some of his accolades include several Grammy nominations, BET, and MVT awards. Back on April 20th, 2022, at the LAX airport, APRocky was arrested and charged with 2 counts of assault with a deadly weapon. Now, flashback to November 2021, him and fellow ASAP Mob member Tyrell Efron, or ASAP Relly, got into a heated argument, and it ended up with ASAP Relly claiming he had been intentionally shot twice in the hand by the defendant. January 2025, the defendant pleads not guilty and takes his chances with a jury trial. Now, there are a few questions within this case. One, ASAP Relly, the victim, claimed that one of the prosecution's main pieces of evidence, a voice recording of ASAP Rocky, insinuating that he paid off the victim in exchange for him not to take the stand as a witness, was actually AI generated and had no merit. And this fact was confirmed by the victim. Two, Rocky's team, along with multiple witnesses, claims he used a prop gun or a non lethal starter pistol with blanks just to defuse the situation. Previous to this, Rocky had an alleged stalker and claims that he carried around a prop gun strictly to scare them off. Yet another question remains in the fact that many people believe ASAP Rocky was overcharged in this case. At the end of the day, the only injuries that occurred during this alleged shooting incident are scrapes on the victim's fingers that could very well have came from punching a door or anything else.
Now, I think that she should have said come there, but I'm not sure.
Lastly, the police reported to the scene the night of the incident and concurred that not only was there no shooting, but there were no crimes taking place that night at all. No arrests were made, and the victim went into the station and filed a report himself days later, alleging that the scrapes on his fingers were a result of being shot. If proven guilty, Rocky could face 24 years in jail. On Thursday, the 13th, the prosecution and defense will be giving their closing arguments, and Defense Diaries will be covering it, so make sure to tune in.
There you go. It's pretty dope. Pretty good. All right. So let me see. So yeah, that's tomorrow. So that will be tomorrow, and we will be covering that, or Allie will, because I'll be flying, I think, when that's going down. It's a Cali case, I believe, somewhere on the West Coast. So it's going down at 9:30 out there, and we will obviously be East Coast because we're down in Florida. So we will be going live at, come on, Mandy. We'll be going live at approximately 12:30. She might go a little early. We were trying to figure out where she can actually record from that's like suitable. So we're trying to figure that out. It might have to be a closet, so no judging. It's a traveling show, so but yeah, that'll be interesting. I'm gonna probably get Wi-Fi and hang with y'all in the chat while she's going live, because I think I'll be in the air probably for the better part of it. But I'm anxious to see it. So make sure you're checking us out tomorrow. Hit your notifications. And I'd also like to thank all of you for your kind thoughts. Thank you very, very much. It means a lot to me. I was able to see him last week. I flew down there. I don't know if I had mentioned that to y'all. So I did. And he had a day of lucidity where, I was really actually able to have a conversation with him for the better part of the day. So that was huge for me. And that really helped. I think if I had not done that, this would have hit me like a ton of bricks. But getting down there and seeing his condition and getting a better understanding of what was going on, I was able to prepare myself for it. So my dad's a big puddle down there, though. So yeah, there's that. Okay, let's swing over to, what do you think? Let's do Boswell. All right, let's pull Boswell up. Now, what I'm going to do with Boswell is I'm going to try, and if you don't know anything about that, it is Megan Boswell is currently standing trial. They're actually in verdict watch in that case, as closing arguments were today. I believe it was a 7-day trial, including today. And she is accused of killing her 15-month-old daughter, Evelyn. Another one of those cases that just makes you die a little bit inside. Just a brutal case, hard to watch. It's like in the same kind of territory that we've got with like the Adam Montgomery thing, man. It's like I never get it. I never understand it. I never understand it. And the more, and we, again, this was a case that we didn't follow over here. I know that Giselle is following it, and I know that she's been broadcasting the trial on her channel. And it's a tough case. It's a tough watch, and it's an interesting case in that I hate to say it, it has a lot of elements, at least to me, of kind of the Casey Anthony situation, wherein they really don't know how Evelyn died, and when you're trying to get a conviction for first degree, you have to have that premeditation. But the biggest thing that you have to be able to prove is that she was intentionally unalived. And, this is one of those cases I hate to like be, you know, kind of the bearer of bad news. I'm not sure if the state was able to prove that part of it. And that's why you saw a lot of stacking of charges in cases. And stacking of charges is a term that they use when prosecutors throw a whole bunch of charges at a defendant, and it serves a couple of purposes. One, they do it early in the hopes of being able to get that person to plead out, because of just the enormity of the amount of charges. And, when they go and get arraigned and the judge is going through all the charges and he's telling that defendant all the possible penalties in terms of time that can be served, it's very intimidating. It's very, very intimidating. And we try to explain to our clients that this is what they're doing. It's a move. That there's charges that they have lumped in there, but you can't be sentenced for the same crime if you've been convicted, if they've charged it in different ways. Because understand that in most statutes there's subsections. You can charge it in various ways, and that happens all the time in courtrooms all over this country. It's a very effective tool for the prosecutors, one in which I hate. I think that it forces pleas for cases where people didn't actually commit the crime, but they're so afraid of doing the time that because of the mere magnitude of the number of charges that if they're offered a deal, that they're like, wow, man, like how do I've got 50 years sitting here combined with all of these charges, and they're offering me two. Am I willing to take the risk and go to trial because they have some evidence, and they have their narrative? So at any rate, there was I've got a few points of the closing arguments that I've noted that I'm going to kind of skip through. I wish I would have had time to make a video so I didn't have to do this manually, but I'm going to go to I thought that this was kind of interesting. I actually like the prosecutor's approach here on how she explained to the jury the concept of reasonable doubt. I thought it was effective. And she used a little demonstrative evidence, albeit a little bit primitive, but I'm old school. So, I was all here for it. This is probably what I would do, instead of putting something fancy up on the screen, I'd get a big old pad and scribble some shit on there for the jury. So let's pull this guy up here. So again, we're going to look at the closing arguments of the Megan Boswell trial, which was at day 7, who again stands accused of unaliving her darling 15-month-old daughter. Just sickening case, really, in a lot of different ways. All right, so let's pull this guy up here. Get this guy full. Now, I'm going to warn y'all, as far as the sound on this one's not great, so I'm going to boost it and I'll keep quiet because my mic's going to get boosted as well. And the sound on Brad Simpson is awful, and the sound on the Shannon Gardner / Jared Brightigan is bad too. They're bad. Like they're just and remember, like a lot of what we're going to be seeing today are what they call status hearings, wherein it's not a hearing set for motions to be argued, or they'll have the courtroom set up. They'll usually set aside a full day for just that case. These are full docket calls. They're being called up along with a bunch of other cases. Especially with Simpson, you'll see the other county inmates that are awaiting trial sitting in the juror box over to the right hand side. They have Simpson in back. I don't know why they had him in back, but and the sound on that's brutal. So, but we're gonna go through them anyway. All right, so this is Amber Massengill, who is the assistant DA, who's been trying this case. And this was just a little part that I thought was pretty interesting.
Know 100% what happened. That is not what is required by the law. It is not absolute certainty. It's essentially, can you go to bed and let your mind rest easy? Can you, actually, I'm going to do one other thing real quick. What I'm asking you to do is essentially use your own common sense. That's one of the most important things. Okay. And I'm going to give an example of what I mean by this, if I can. It's like Wheel of Fortune. Okay? My handwriting's not the best though. But you get the idea here. It's like Wheel of Fortune. When you see a contestant on Wheel of Fortune and they know the answer to the phrase or the statement, they don't have all the letters when they see that phrase, but they know what the answer is. And if the state has done that, we have met our burden. And it's important to note that it's not beyond a shadow of a doubt. It's not absolute certainty. That is not what is required by the law, by the state of Tennessee.
So I thought that was pretty neat. I thought that was a pretty good way to show in a demonstrative type of way what beyond a reasonable doubt is and how circumstantial evidence works, and that you're going to have little holes. Like I usually use the jigsaw puzzle kind of analogy where you've got some missing pieces and maybe, there's some holes in there, but when you step back, you can pretty clearly see the whole picture. I like that. I bet you she's been using that for a while. I think it's a pretty effective way to get the jury to understand exactly what reasonable doubt means, and explaining beyond that what beyond a reasonable doubt means. Yeah, Sleuthy, my uncle had passed. Sleuthy texted me. So I'm heading down to Florida tomorrow for a Friday memorial. So I thought that was interesting. The rest of her closing, and I don't know if you guys watched it, I didn't think was phenomenal. I thought that she was effective. I think that it's a tough case. Like I said, it's a very tough case for the state in that their medical examiners could not, neither one of them, they put two on, they could not get on the stand and tell them what the cause of death is, which is a real problem when you're trying to prove an intentional homicide. Now, and that's what I'm saying, like some of the parallels that I see with this case and with Casey Anthony, where they had such a hard time with that part of it as well. In that case, obviously there was a longer period of time before Kaylee was found, but it was still a problem for them, and we all know what that result was. I did a thing with Josh Ritter today for his podcast thing, that not on Courtroom Confidential, and we were talking about this case, and I'm like, man, like I always rue being the one to like say this because everybody hates this woman. She's a lying little piece of shit. She's awful in so many ways, but the fact still remains that you have to take emotion out of this. This isn't about emotion, and we all feel emotion when we hear about a 15-month-old child losing their life. You know, we all feel that deep inside, and we want somebody to pay for it, especially if it's a parent. You know, it's like it's the biggest breach of love and trust, and just it's hard to fathom. Like I can never wrap my mind around it as being a father. It's just it's unthinkable to me. So it really is difficult for me to be able to know what that mindset would be like in order for you to be capable of doing that to your own child. It's impossible for me to get to, which gets me to, I'm going to go right into the defense closing. He pops off quite a bit, and I went to it, and I'm curious to see, and I want to see in the chat if you guys think that it is if it's effective. So 'cause she went on for quite a bit, and you know she went through the evidence, and you know she was big on the fingerprint on the tinfoil was a big thing for her. He addressed that. But what I thought was most interesting in his closing was probably right around in this part. I'm gonna go back a couple bloops, and he starts out real even keeled, and I just want to know, and you know this is one of those defense attorneys that's got a job to do. That I'm sure if I were in the chat over at the Grizzlies or on Court TV or wherever, people would be talking about how they hate this guy. I mean, he's got a job to do, you know. So keeping that in mind, I want to hear what you guys have to say about what you think about this particular part of the closing.
They haven't proved she's murdered. You have more counts of false report than I can really count. I think there's 11 or 12 of them. Almost every time she.
Now I know that the sound sucks, right? Bad sound. So, and there's no captions. Well, actually, maybe there are now. Let me see. All right.
She's talking to law enforcement, you're considering a count of false report. With the exception of, you're not considering one for the time she talked to Agent Fraley. That's not before you. I would submit to you what happened was the conversation with Agent Fraley on the 25th of February, almost 5 years ago. That was a breaking point. That's a breaking point where she finally admits Evelyn is dead. She's able to admit to herself. You saw all these pictures she's sending back and forth before that. That's how she's grieving. Maybe she doesn't want to accept that the child is dead. Maybe as long as she keeps talking about it, talking to the media, talking to the police, and saying that Evelyn is somewhere else, she believes that. Maybe that's how she's getting by. You can't judge someone for how they grieve. You don't know what goes through their head. You don't know what they were raised with. I've never lost a child. I hope none of you ever have. But how am I to tell someone when they lose their child how they grieve? How am I to do that? Amber can tell you that. Oh, she shouldn't have went here. She shouldn't have did that. How does she know that? She's not in Megan's shoes. She's not out there living in that single wide trailer. That's not her life. She's not been raised by drug addict parents, a dad that beats on her mom constantly, and seen that growing up. She's not seen that. She can't put herself in her shoes. It's not fair to say she murdered her child because she didn't grieve right. I resent it. You should too. You should look to the evidence in this case. Do they prove a cause of death? That's the stopping point on the homicide counts. They can't do it. They brought 2 medical examiners in here who contradicted each other. The first one at least had read her medical records. The second one talks about how she is perfectly a healthy child. She ignored everything in her medical records. She didn't talk about it. It was obvious to me. Should have been obvious to you. She hadn't read them. She didn't care. It was her job to come here and convict Megan Boswell of murder. If you don't believe that, why would she leave here and say, well, she must have been murdered some other way? She was a biased witness, and she wasn't a credible witness. Now, let's talk about the tinfoil. How?
So he gets calm. He automatically gets calm right there. So I can see from some of the comments. Now you can see, like, leading up to that, he was very calm. And then he got animated. He wasn't yelling at the jury. He was yelling in front of the jury. It's different. It's different. You know, and it's sometimes it's effective. Sometimes it's not. You know, you never know as a lawyer how that's going to play out. You just don't. You can't. And, you know, sometimes a show of emotion by the attorney will emphasize a point that he was trying to make, which is a valid point. You know, it's like that thing I'm always talking about, how prosecutors and cops and defense attorneys weren't there when the crime was committed. They act like they were. They say things in definitives like, that person did this, that person did that, this is what happened. That's the job, right? You can't come in there saying, we think, maybe, you know, it's a theory that we have. Like, you come in and you argue in definitives. The reality is that they aren't definitives. And I personally, even though I probably would have toned it down a little bit, I like that he challenged the prosecutor in terms of her pretending that she had any idea of how somebody should grieve. Because unless you live in that person's life, unless you walk in that person's shoes, unless you were brought up the way that she was brought up, you have no idea. You have zero idea how you would respond. And, you know, I mean, the biggest problem with this case is that you have a child having a child. You have a 17-year-old who clearly was not mentally prepared to have a child, to be a parent. She wasn't financially prepared to have a child. She didn't have the kind of support that if you are very young having a child, you're going to fall back on your parents to help you. She didn't have any of those things. And I know that her father got her a car and a trailer, but that's just stuff. That's not support in the way that you need it when you're raising another human being. So I thought that was, we'll see how it was. I mean, I am sure that there were people, my friend Kirk Nurmi thought that this thing was going to be back in deliberations for a half an hour, is, you know, open and shut. She's done. Telling you, it went 2 hours, 45 minutes deliberating. They're coming back at 8 in the morning. They're going to continue to deliberate, and we'll see where it lands. But that being said, I did like the rebuttal closing. So I'm going to skip to the beginning of that, and we'll watch about 5 minutes of that, because I think it's pretty good. He gets started right in here somewhere.
Some very convenient explanations for. Ladies and gentlemen, much like Megan Boswell, Mr. Scott seems to have some very
Is that too low, y'all? I took the booster off because it seemed like it was screaming with it on. I'll play a little bit. Y'all let me know if it's too low.
convenient explanations for what happened in this case. Lots of things that happened in this case. All of the evidence in this case that points to his client, he's got some sort of explanation for it. But the problem is, in order to buy into this, in order to believe it, you have to believe Megan Boswell. You have to believe that when she spoke to Agent Fraley on the 25th, that she was somehow, for the first and only time in this courtroom, speaking the truth. But I think each of you, as you sit here, know that's not possible. That's not possible. Megan Boswell is one of those people. You used to hear the expression, the truth ain't in them. The truth's not in Megan Boswell.
The truth ain't in them.
She doesn't know how to tell the truth. Everything that she tells to every person in her life is for some reason. And that reason is because Megan's trying to get something out of it. She is a master manipulator. Even at 17 years old, you sit there and watch those videos. She's trying to play everybody. She's trying to play the law enforcement officers who are interviewing her. She's playing her friends. Every person in her life who walked through that gate and sat up on that witness chair was in some way manipulated by Megan Boswell. Some way. Whether it was about Evelyn, whether it was about how she was going to pay for a babysitter, whether you're the father of my child, whether you're a great-grandfather, whether your wife who's dying of cancer is babysitting the kid. I mean, she knows no bounds. There is no person that she will not manipulate and tell untruths about and to. No one. But Mr. Scott comes in here today and says, yeah, hey, come on, ladies and gentlemen, the 25th, you could, that was the point, which she decided, hey, I'm going to be truthful here. No, it wasn't. No, it wasn't. No, we know it's not. It was just another story. She was telling law enforcement to lead them some other way. That's all it was. And if you remember, Agent Gratz testified. General Massengill was asking him the question, when did this first thing about accidents and rollovers, when did that come up? Well, it came up when the police and law enforcement finally said, yeah, we got nothing going on here. We got to give her an out. We got to give her something so we can try to find this kid. So
This was super effective. Like this, I promise you resonates with the jury. This exact argument right here, because that's what happens. It's in like a read technique type interrogation when they're not able to succeed in any other way in terms of getting her to talk what they feel would be honestly. They come up with the concept of like, how do we give her an out? How do we, because a lot of times, you'll hear it in an interrogation where they'll be talking about like, oh, well, we know you did it, but man, like something happened. It was an accident. You didn't mean to do it. We get it. Like something just went awry. You know what I mean? They'll always try to create a situation where the person that's getting interviewed feels as if they are in a position then to admit it because the cops are making them think that it was justifiable in some sense. And that's what he's arguing here.
the ones who suggested it. And then very conveniently, the next day she comes in and guess what? Oh, yeah, I forgot. Yeah, that's right. I'm sorry. I'm sorry I've been lying to you all for days and days and days now. But now I'm going to tell you the truth. But that's not what happened. That's not what happened. I submit to you, the only time that Megan Boswell may have told the truth about some small portion, if you remember during one of the interviews, Lieutenant Price, who had been very patient with her up until that point in time, finally said, come on, something happened on December 21st. And she stopped him and corrected him. Remember? She said, no. Something happened before December 21st. Yeah, something did. She murdered her child. That's what happened before December 21st.
Dixie, it's your birthday? Aw, happy birthday. Happy birthday, Dixie. We love you over here. Yes, we're doing late night. I had other stuff going on, so it was now or never. It's now or never. Happy birthday. I hope you had a glorious day. I mean, I hope that you're here with the wrench is not indicative of the kind of day that you had. I hope that you had a great day. We love you over here, and we hope that you have many more. Loop, Mandy, looping.
First. Ladies and gentlemen, before I speak further about the physical evidence that ties and shows that Miss Boswell is the one who is guilty in this case and who needs to be held accountable, I want to take you back to jury selection. Last week when you all were first up here and up there, and I asked you if all of you had brought your common sense with you. And if all of you, as you listen to the evidence in the case, would use your common sense. And everyone agreed that you would. And so I want to remind you of that. And it reminds you to apply that to the evidence that you've heard, the testimony that you've heard in this case.
All right, so you can see the state is leaning big into using your common sense. That's a common theme running through the initial closing and also the rebuttal closing. And that's an argument that the state will use in a circumstantial case where they know there's some holes and they're basically arguing Occam's razor. Like, you know, the simplest explanation is usually the right one. And that's what they're saying here, you know, that there's no other explanation for how this 15-month-old child died. You know, SIDS doesn't seem to fit, you know, and just so you all know, the defense put on nobody. It's that big risk you take as a defense attorney where you are waiting and weighing at the end of the state's case in chief as to whether or not you should put forth any defense. Now, when I was talking about this with Josh, we were both kind of the mindset like, well, who are you putting back on, or who are you going to put on the stand? And it's tough. You know, are you going to put character witnesses? I mean, a lot of the character witnesses that came on in terms of talking about how they saw the child in states of neglect, dirty, unkempt, you know, but those people also had decent things to say. You know, the pediatrician said that she was bringing the child to the doctor when she needed to, that she was getting the medicine when she needed to. So there was kind of like good and bad that was coming with that. So it's one of those things where, you know, when it gets to your case in chief, short of you having a medical examiner who's going to end up having the same problem that the state's second forensic pathologist had, which is that person did not physically examine the body. So you've got somebody going off paper. Those are experts that are very easy to attack because they're basically having to go off another person's work as opposed to being able to examine the body themselves. So, you know, I mean, it tells you one thing, that there is no affirmative defense, and that what the defense is leaning into completely and totally is reasonable doubt, and that they don't believe that the state has met their burden, even though I'm sure there was a motion for a directed finding or a directed verdict that happened after the state's case in chief ended, and I'm sure that was denied. They always are. Sometimes you'll get a charge kicked, but it's very, very rare to see an entire case kicked. Frankly, the only one I can remember in recent memory And it wasn't even based really on a motion for a directed finding because the state was still in their case, was Alec Baldwin. And we know that was, that was mind blowing to see that whole thing go down. So, yeah, so it stands right now. They're 2 hours, 45 minutes into deliberations. And I anticipate this will probably end up getting a verdict tomorrow at some point. We'll keep an eye on it. We'll keep an eye on that. So that's Megan Boswell case. All right, let's flip over to let me see. Is this the right shit? I don't know what this is. I don't even know what that is. I don't even know what that is. Okay. Oh, that was something else. All right. Okay, so let's go. Let's flip over to Brad Simpson. He is, of course, this is down in Mandy's neck of the woods, down there in Texas, and he is accused of unaliving his wife. And it's one of those cases where he left quite the breadcrumb trail for law enforcement, and it's he's just a guy that you can't help but kind of hate. So when I saw him today, I was like, wow, he does not look. He does look worse for the wear. Oh, Bear County. Thank you. What did I say? Bexar. Yeah, I didn't say anything this time because I couldn't remember how you pronounce it because it's been a minute. And this case is gagged. So it appears that they're going to be having hearings to the public that will be accessible to the public, which is good. This is a case that I definitely want to follow. So let me pull this guy up here. And not much happened here. This is what I was talking about with the status. Kind of the reason that I want to show it is that his attorney is going to mention their speedy trial demand. And I found it a little bit interesting in terms of how the judge seemed to kind of ignore it. I'll point it out when it happens. Speedy demands are serious for the state. And, you're going to hear there's some discovery issues and, it's a dangerous gambit, having a speedy demand because yes, you're forcing the state ahead of what they would typically like to where they typically like to be in terms of preparing for trial. These cases just take a long time to get to trial. That's why it's always over a year typically, unless there's a speedy demand. And this judge kind of surprised me when he came. I'll point it out when we get to it.
2024.
So he looks like shit.
CR 012094.
Got that jail hair.
CR 012095.
Guarantee is that jail smell too.
CR 12097. So will the lawyers please, State of Texas versus Brad Chandler Simpson, will the lawyers please identify themselves for the record?
Case to stand up for the state of Texas.
Stephen Gilmore for Mr. Simpson.
Okay, and sir, are you Brad Chandler Simpson?
Yes, sir.
Okay, so we had this case originally set for today. I thought for the motion to quash, but it's my understanding that we're not going to argue that today. Correct?
So, yes, Judge. So discovery is not yet complete, and I'd like to have all or nearly all of the evidence before proceeding to that particular.
If y'all aren't familiar with this, we did a pretty good recap of this case. It's in our lives. If you just search for it, maybe one of the mods could link it in here. It's pretty thorough. Gives you kind of the timelines, the locations. I threw some maps up there, and we went through the entire probable cause affidavit, which really laid out the state's case pretty nicely. And it's worth watching. It's an interesting case. I think this guy's screwed, but you never know.
Particular hearing.
Correct. Okay, now the other reason for this type of hearing is just to make sure where are we on discovery, that the defense is getting discovery in a timely fashion. What can the state say about that?
Yes, Judge. I provided about a terabyte or so of data to Mr. Gilmore And I've got more to give to him today. I got a new drive to copy some things. I expect.
Now, old judges, because we hear terabytes all the time now in court. Oh, I gave him 15 terabytes. Yeah, they got 11. This old judge, you think that guy, you think Joel Perez has any idea what a terabyte means? Any clue? I can guarantee you Judge Perez has zero clue what a terabyte means.
First, a draft of discovery from Almost Park tomorrow, finalizing their discovery. The Rangers are actively working on theirs. There is some outstanding forensic testing being done that we're still waiting on results back, but I expect in the next 2 weeks or so, we should be getting close to a final draft of discovery.
Okay, and counsel, anything you need to add on that as far as receiving discovery?
I mean, the Texas Rangers dropped off a chunk of discovery to the state just before the new year, and it had turned out that they had given the state all of the original copies of that discovery. And so the state had to transmit that discovery back to the Texas Rangers for duplication. I don't really know why the Rangers have taken almost 2 months to duplicate that stuff for us, but
I am the elderly.
I don't have that. I just want to reiterate that we filed a
I don't know what the hell a terabyte is. What is that? It sounds like a lot. Is it a lot?
Assertion of defendant's right to speedy trial back on November 14th. So I am looking to get this case in front of a jury as quickly as possible.
Okay, and state, I guess you're exercising.
All right. So you hear that, right? They got the speedy demand. I'm looking to get this in front of a jury as quickly as possible. Thanks, Afton. That still means nothing to me. Like, I don't know what that translates into in terms of paper, you know, or video or sound. It's like it means nothing to me. It's a word.
Your due diligence in trying to get the Texas Rangers to give you that?
We are, Judge. I asked for those to be copied. It is quite a lot. We're looking at between 5 and 10 terabytes finally of data. So they're working on finishing supplements, and they should get that back hopefully within the next week or two.
Okay, well, that is a lot of information, counsel. So we're going to give them some leeway on that, and plus you need it.
Understood,
regardless. Does the defense have any other motions that have been filed other than the motion to quash that we're not going to hear today?
No, Judge.
Okay, so with that in mind, in light of the fact that you're getting this discovery right now, there's no sense in coming back in 30 days. Let's do a deal.
See, this is it right here. Now he's got a speedy demand. In custody, it's typically, I'll have to look it up in Texas, but it's usually 180 days. You got to bring this shit to trial, like impaneling a jury. And if the state's not ready, and if you don't answer ready as the defense, if the state's not ready, your guy walks. You know, yeah, ChatGPT is not my best friend. Lisa must not know how I feel about AI. I mean, I'm caving because I have to, otherwise I'll get left in the dust. But definitely not my best friend. It's going to be I'm going to do a live, and I'm going to read that letter that I'm always talking about from the godfather of AI who sits on the board, who wrote his own letter, open letter, and that was published in Time or something like that. He was sitting there weeping. Oh, God. Yeah, it's that guy broke it down in a way that was pretty clear. But point being, this judge, when he starts talking about the timing of the motions that have to be filed, what it tells you is the judge does not believe that this defense attorney is going to be ready, and that ultimately they're going to waive speedy. And you can tell because of what he says right here.
You all want 60 days or 90 days?
60 or 90 days.
I'm fine to come back in 30, Judge.
Okay, well, I'll leave it up to you. So we'll reset it for 30 days just to make sure that things are moving along. Okay.
Thank you, Judge.
So we set 30 days and give them the dates, and then we'll see you here then. Okay?
Thanks, Judge. May we be excused?
Yes, you're excused.
Appreciate you.
All right. So quick and painless. So here's the issues with this case. He does have a speedy out there, and he's been in custody for a hot minute. Mandy, what do you think? Like, I can't remember what the date of arrest is, or when we did that live right around when he got arrested. And it's from the minute that you're in custody, and you're arraigned is when that clock starts to tick in terms of your speedy demand. Now, I don't know if he made it right away, and they're going to be running up against it. You know, you're talking basically 6 months. So they're going to have to hurry. They're going to have to hurry, including the defense. You know, the defense has to try to get all the discovery in, has to get through all the discovery, has to file all their motions, and they have to get litigated prior to trial. So it's very challenging for both sides. So that's Simpson. Again, I do have a pretty comprehensive recap of that case in the lives. Go back and watch it. It's pretty good. We break it down for you. We give you, like I said, the entire probable cause affidavit, break down timelines, because this is like what's his face in the other case in Canton that Judge Cannoni's on, Brian Walsh. That case, it's like identical in like almost every way. Same. This guy was doing the same kind of shit, driving around, getting rid of shit, you know, leaving evidence all over the place, and it's a very, very similar case. All right, so next, let's go to Stephan Stearns, the giant creep that is alleged to have unalived Madeline Soto, and see what's going on with that guy. This again was kind of a bit of a nothing burger over there, and it was interesting though, kind of, somewhat. Now, I'm going to boost it here because the sound definitely stinks here. It's not good. So they waived Stearns' appearance. I don't know if you heard that. So I'm curious, are we going to have another Adam Montgomery situation here with this guy? Maybe not. It's sometimes if it's a status and he knows ultimately what's going to be going on here is they're asking for a continuance. Now, Stearns has different cases up. These are all the sex crimes. So, you know, he's got just a massive amount of sex crimes that they charge him with that are separate. It's a separate case from the homicide case. So this one was set to go pretty imminently, and it's going to ultimately end up getting continued. Spoiler alert.
Accepted. The court has also received what's reported to be an unopposed motion to continue. I noticed from reviewing the docket, there's been 3 motions to suppress evidence filed on February 6th. Looks like those motions deal with a search and seizure of a cell phone and material contained therein. Those been coordinated with my office since that we're here. That have been continued twice before in April and July. Obviously, public defender's been on the case for almost a year. When do you anticipate resolving these motions?
There's one other motion that I have to file, and I'll be asking the court to hear before the motion to suppress. I intend to get that motion filed by the beginning of the week, and then this week, but I'll be reaching out to Ms. Hackman.
What's the substance?
Certainly regarding the
Ms. Fennell, the motion to continue was reported to be unopposed. These matters need to be resolved prior to trial.
For the integrity of the case, yes, Judge. The evidence viewing that was scheduled in this case ended up having to be canceled because both Ms. Smith and I ended up in trial, and the other attorneys were not available either. So that is scheduled in March, and I don't believe that we would be able to proceed to.
Oh no, Joe, I'm so sorry. And I promoted that today. I did not mean to do that, dude. I'm so sorry. You know what? Let's make it up to Joe. Can you all make sure that you post Joe's channel over in here? He had a pretty awesome interview tonight that I actually am going to replay crew myself with Lori Vallow Dables, one of her cousins, who I'm sure was dishing dirt. So throw that up. My apologies, Joe. I forgot to, you know what? I meant to ask too, because I asked if Steve was going live tonight to Mandy, and I meant, because I wasn't sure what day. I didn't know if you were today or if you were tomorrow. Because my dates are a little screwed up, man. I got some other real life stuff going on. So my apologies, brother. But everybody go over there, check that out. If you check it out on replay, you know the drill. Leave a comment or two, get that thing flowing in the algo so we can get our boy out there, help his channel grow. Sorry about that, buddy.
Trial until the defense has had an opportunity to review that evidence and these motions are resolved.
Right, the matter is going to be continued without opposition from the state. Our next trial is going to be on April 22nd, with a trial period that begins May 5th and runs through May 21st. My apologies, April 23rd will be the pre-trial date with a trial period that begins May 5th through May 21st. Anticipate that the motions and hearings will be scheduled in advance, heard and resolved in advance of the April 23rd pre-trial date. Anything further?
But I have a proposed order for you.
Thank you.
All right, so that's it. They got the continuance was granted. This case is kicked until May 5th for trial, and that's to go through. He said it for about 3 weeks, which it's a lot of computer and phone data because this guy's one of those super creeps. And we'll see what goes. Like this is what I was talking about with this is a stacking case. Because I think they've got really good evidence against him in the homicide case. And it's going to be one of those cases where everyone's going to hate that guy because he is imminently hateable, and he is just such a massive creep, and it's going to that case is really disturbing in a lot of different ways. I'm still waiting for the other shoe to drop. Waiting for mom to get charged on that. All right, and then so let's do Shannon Gardner. This is an interesting case. It's got a lot of Adelson vibes to it. It's a murder for hire, ex-husband gunned down in front of his SUV, 4 kids, and it's alleged that Shanna and her lover, Mario Fernandez, were the culprits. And so this is up. This is the case I definitely want to follow that trial. Like once it gets rolling, it's going to start picking up a lot of heat. So it'll be one that we'll cover for sure. All right, so let's see. And again, crappy sound on this one too, y'all. There's nothing I could do about it other than crank it with the booster. All right, get this thing. The judge rolled in late, Judge Kite. She's looking a little frazzled initially. I've had that happen where judges are late. You can tell they just walked into the building for their 9 o'clock call. They're a little bit frazzled. I mean, some judges don't care. Like they just don't value the attorney's times at all. And they just roll in there whenever they want. Like Cook County, which is where Chicago is situated. A lot of those judges just don't care at all. Just roll in whatever. You'll sit in the courtroom for an hour, 15 minutes waiting for the judge to take the bench.
Good morning.
Morning, Your Honor.
Good morning.
Christina Stephan for the state. Number 1, Mario Fernandez Saldana. Number 2, Shanna Gardner.
Thank you. Good morning, everyone.
Good morning, Your Honor. Patrick for you, Ms. Gardner, Jesse Drexler, Fernandez, along with Mr. Hill and Ms. Day.
All right. If we could, will y'all give me an update about what happened in the meeting
Secret Service spoke to Ms. Medina from Bias Firm and Ms. Day from Dreiser Hill and myself. They need your honor to amend your order to allow them allow me authorization rather to receive the evidence from them in a correct format and transport that to Mr. Gano.
I need to amend the order for
They
Secret
were-
Service to provide the information to who? You?
Yes, ma'am. They were very hesitant to do anything without authorization from the court. So they have the correct format of the evidence that needs to be given to Mr. Gano. They just would feel more comfortable if your honor's order specified that I could coordinate with them to receive that without them reviewing the content of it, just downloading it onto a drive, same as we did previously, giving it to the state on a password encrypted hard drive and transporting it to Mr. Gano in the correct format.
What is in Mr. Gano's possession?
The raw data and PDF of the cell phone extractions and cell phone extractions. They need it in a UFDR format.
And the Secret Service has
Yes, ma'am.
that. I don't know what are the defense thoughts about it. My thought is that I'm not going to amend the order because I want that to, what I could do is enter an order authorizing transport of property
Sure.
or evidence. Is that okay? I don't want to amend that order. I want the order to stand. And y'all, because it's not really a review, it's just a transfer of property, right?
Correct. They just weren't willing
I get
to
it.
do anything without the court expressly saying it was okay.
Okay. So I need to authorize the Secret Service to transfer the property to the state in an encrypted form. I'm just going to say, I don't want to get too specific. So Secret Service to the state.
Yes.
Okay. And then state to Mr. Gano.
Yes, Your Honor. And that the secret.
Why can't, or the state is just going to transport the property to him?
Yes, Your Honor.
Okay.
I spoke with counsel yesterday. If they have an alternative, they want to use a third-party courier or something along those lines. It would be quickest for the state attorney investigators to drive it there.
I thought we talked about that and not like putting it,
Correct.
I love you too.
if it's in an encrypted form.
There's no way that they can email Mr. Gano the password directly or give it to him directly. So there would be no way for anyone transporting it to open it and access the information if it's encrypted
Is that
without
acceptable?
the encryption key.
That's acceptable for Ms. Gardner, Your Honor. Acceptable.
Okay.
Oof.
Is there?
They're here.
Point of contact?
They're here,
with
Megan.
the
I swear I'll send them.
United States Secret Service.
Christopher Larson is the deputy special agent in charge. LARZEN.
I'm gonna LARZEN.
Yes, Your Honor.
Okay. Okay. Got it. I'll do that.
Thank you, Your Honor.
In the meantime, I did see that the defense has filed a motion to obtain Mr. Tennant's jail calls.
That's correct, Your Honor. We provided the court a draft order, and our understanding is that the state takes no position on that motion.
That's correct, Your Honor. I think
Okay.
that's a JSO defense counsel issue. I have no objection to it.
Okay, I'll do that. I'll sign that order then.
Thank you, Your Honor.
Is there, when I was looking at the order, is there anything, like, does GSO require some type of time frame or just any and all?
Any and all, and
Okay.
they'll process it. If we upload that to their public records portal, they'll process it.
Okay.
We were in the process of drafting that same motion. We had board tentatively adopted today. Because I don't want JSO to only provide it to them. So you would include both defendants now that we
No, I can do that. But you will follow up with something documenting the record that you adopted it? Okay. Let me see the attorneys at sidebar.
Right through that sidebar. Mandy, where's the shots? Shots, Mandy.
Do they need his jail number? Or this is fine? How do they categorize?
They do it by their PIN number, which is their JSO ID. I can give that to
Can
Mr.
you-
Hathaway.
Okay, can you? All right. So we were discussing some logistical things with the evidence, and the defense is going to prepare the proposed orders. There's no objection by the state, correct?
No, Your Honor.
Okay, so if y'all get those together, if you would give a draft copy just to the state so they can review, and as soon as I get kind of a thumbs up from the state, since they don't have any objection to what I've explained the process to be, and what I would like to do so that we don't run into any issues. I know, Ms. Stifler, you don't have an objection, but if you could please contact the Secret Service, let them know what the thought process is, and if there's any issue with them giving the unredacted evidence in a usable form to the defense, if you would kind of work with the defense in whatever language the Secret Service feels comfortable with, and so that we can, so once I sign the order, it will actually get accomplished, okay? Because I don't want it to go over there and they're like, this violates 18 USC, whatever they do, okay? All right, so we are gonna come back on, what was the date, March 28th? On Mr. Fernandez's case, Ms. Gardner's case, how long do y'all think for a case management hearing?
90 minutes.
Right, hour and a half.
Okay. Morning or afternoon?
It's a
Friday. Well, I only have the morning now.
March 28th.
Morning,
Sorry, what was the actual date?
March 28th. Morning,
Morning is agreeable with the state.
Yes, Your Honor. Tomorrow,
9:30.
9:30.
Yes.
All right, there you go. So, and I think that one's tentatively set for trial for September, I believe. Don't quote me on that though. Could be wrong. Could be wrong. All right, so now we're going to flop over to Karen Reed. The case is getting very, very busy. Very, very busy. Flurry of motions came in today as we all eagerly await the motion to dismiss from the state. That one we already went through, so we're not going to go through that. So this came in, and this is a motion of the defendant to exclude the testimony of the Commonwealth's witness, James W. Crosby, PhD. And the exclusion of the testimony is compelled because it fails to meet each of the two prongs, the main two prongs of Daubert-Lanigan inquiry, qualifications and methodology. That is, Dr. Crosby is not qualified to render the opinions he proffers. It is undisputed he's not a medical doctor. He thus fails per the crucial qualifications inquiry of the Daubert-Lanigan standard. This failure is not curable. In addition, the methodology that he invokes in his report is not reliable. Among other defects is his methodology. In his methodology, there is no showing that is generally accepted in the relevant medical community, and the methodology is replete with errors, as is demonstrated in the affidavit of Dr. Marie Russell, which is submitted in support of this motion. The failure of either Daubert, Lanigan prong requires exclusion of the proffered testimony. Dr. Crosby fails both prongs. So that's the thrust of that. They're trying to keep out their wound expert, who's going to come in and obviously try to say that they're not dog bites or canine bites. Also filed was the affidavit of Robert O'Neill in support of the defendant's Rule 14 and 17 motion for court order authorizing defense access to the Lexus and Traverse and to the driveway at One Meadows Avenue in Canton to conduct independent testing and analysis. So here they're obviously trying to get black box info from both vehicles, and that is obviously Karen's Lexus and John's Traverse, as well as the camera footage from that we've seen that video so many times where you see Karen backing up, and they were able to show that the car moved by using that ingenious way of pointing it out by looking at the tire as opposed to the vehicle, which was very, very interesting. So there's that. And again, we're going to go through these in full tonight. I still have to pack. I can't do it. So I want to go through them and let you know what's been filed. Also filed was the defendant's motion to reconsider reciprocal discovery order. And this particular motion is regarding the production of impeachment evidence related to the Commonwealth's anticipated trial witnesses. As grounds for this motion, the defendant states that the production of impeachment evidence prior to witness testimony is not required under Mass Rule of Criminal Procedure 14A1B and will unduly prejudice the defense by allowing witnesses to tailor their responses to preempt cross-examination. The production of impeachment evidence related to witnesses proffered by an adverse party is not subject to mandatory disclosure under Rule 14, and in this case would be particularly prejudicial to the defendant, given the public nature of the proceedings and close personal relationships of many of the parties involved. So then they kind of go through the background, and then they'll get into what they're asking for and what they're asking not to have to turn over. So it's relatively interesting. It's a pretty good read. We'll get to it. Yannetti filed a affidavit in support of it as well. This is really dealing more with the Traverse and the Lexus than it is with this particular motion that we just looked at. Also filed was defendant Karen Reed's motion to compel discovery. So the items of discovery set forth herein are relevant and material and must be provided in accordance with Mrs. Reed's constitutional rights to effective assistance of counsel and to due process under the law as guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 5th, 6th, and 14th Amendments to the U.S. Constitution. So here in this one, they kind of break down what they're looking for, and they explain why they want it and why they need it. So that was pretty interesting as well. And then this was also filed, defendants Rule 14 and 17. Oh, wait. I think I already went through that one. Let me see. Boop. Boop. Yeah, I went through that one already. So that was everything that was filed. And like I said, we will definitely be going through it next week. We'll go through all of them, and we will let you know what we think about all of them and how we think they'll come down. So that's it. We're about an hour 15 in. I did a good job. I was trying to stay about an hour 10, hour 15. So I love you guys. Thanks for hanging for a bit. Sorry for the no notice. It's been just a crazy, really 10 days for me. So it's really, really been tough, but you guys make it all worthwhile. Jessica, member for a month. Thank you very, very much. Aw, family hug. So you guys are the best in the business. I love you. Make sure that you're tuning in to Allie tomorrow morning for the closings in the APRocky trial. Make sure tonight you go to our good friend of the show, Joe Schmo. He's got his channel. I think they put the link up in there. Please go check out his interview. It was a really nice get for him. And I feel awful that I impeded on his interview. I never like to do that to my friends. I really do try to avoid that at all costs. So in order to make it up, I would really appreciate if you go over there and check it out. I certainly will be. So do that for me. And then make sure on the way out, you share, subscribe. All those things help the channel grow. We really, oh, wait, let's see, Lisa. You ask a lot of questions, girl. I always see you saying that Bob didn't answer questions. Answering your questions, which I love. I don't want you to stop asking questions. Would be a full-time job, though. Does the lack of incarceration prove the state's accusations of unaliving are lacking? I know her charges for unaliving is second degree. I just lack statistics on detainment until trial for similar charges. Which case are you talking about? Are you talking about which? Tell me in the chat. Tell me in the chat, Lisa, which case you're talking about. Are you talking about Megan? Which one are you talking about? Are you talking about for Karen Reed? No, God, no. Yeah, don't apologize, Lisa. We love the questions. We really do. Yeah, I think she's talking about Karen Reed too. I mean, she was given a bond. She was able to bond out. So, and it was a second degree, it wasn't necessarily, it wasn't like an intentional homicide. Like there, you'll rarely ever see a defendant able to make bond if they even get the opportunity to post bond. So it doesn't necessarily show the weakness of their case, where I will say this, and I have said this a million times. That second degree murder charge in that case sucks. Like they're never going to be able to prove that ever. Like I'll die on that hill. Like I'll make some kind of bizarre bet of something that I'll do that's crazy if she gets convicted of second degree. It's so bad that I think it hurts their case in terms of the manslaughter, because it like when you have those two types of charges, one, they contradict one another. They're like, okay, well, yeah, we're saying she intentionally did it, but just in case you don't buy that, you can fall back on the manslaughter. It undermines their own case. It really does. And they just don't have any evidence. If their best evidence that she did this purposefully are those voicemails of her being pissed off in the early morning hours, then I should send them some of my old cell phones of back when I was out there in these streets, and Allison was calling me when I was out with my buddies, like, where are you? Where they were, she was pissed, and rightfully so. And she certainly wasn't trying to kill me. So, but if that's the best they got, it's ridiculous. Like the state really, 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 really needs to not move forward on that, despite the Supreme Judicial Court's ruling. I mean, if they want to get a verdict on this thing, the only way that's happening is getting rid of that thing. I think you're going to have the same problem over and over again with those two competing charges, which just, it bisects the state's theory. So I don't know. That's just my thoughts on it. All right. You guys rock. Thank you so much, Lisa, for your always support. You're an always giver, and we love you for it. And we love your questions. We love your questions. Don't ever stop. Just don't get mad at me when I don't answer them all. That's all I'm asking. I'm not asking you not to answer. I like when you ask them. Just don't get mad at me when I don't answer them, because I never purposely ignore them. That's for sure. All right. You guys are the best, because without you, I am just an old man talking about a lot of cases. See you tomorrow.
So